Hello, and welcome to this session on grounds for processing personal data. My name is Nuria, and I'm a director at Fieldfisher's Privacy, Security and Information team in London. And today I'm joined by Kate Partridge, a senior associate in the same team. This session is part of our Gate Data Protection Feed program. In particular, this session is module 3 of module 1 of our Get Data Protection Feed program. In this session, we will recap on key data protection principles. We will discuss the key legislative building blocks for lawfulness of processing personal data. We will look at each of the legal grounds for processing under Article 6 of the GDPR and the grounds for processing special category data and criminal convictions data. By the end of this session, you should be better able to identify the key legislative building blocks for processing personal data lawfully, explain the available legal grounds for processing and when they can apply, and identify that additional measures are required for some more sensitive types of data. I will now hand over to Kate, who will start by looking at the data protection principles.
Thank you, Nuria. As Eleanor told us in the introduction to this series, there are several key principles in data protection law. One of the key principles, and our focus for today, requires personal data to be processed lawfully. Now, what do we mean by process? Just to recap, processing is anything that we do with personal data. For example, inputting it into a system, collecting it, structuring it, using it, making it available. But before we can do any of these things, we need to ensure we can identify the lawful grounds for doing this. The lawfulness requirement derives from Article 8 of the Charter of Fundamental Rights of the EU, which says personal data must be processed fairly for specified purposes and have a legitimate basis laid down in law. Today, these lawful grounds are found in the General Data Protection Regulation, or GDPR, and in the UK, the Data Protection Act 2018. In addition, use of personal data must not breach any other laws or be unlawful. By way of example, as discussed in our last session, your doctor has a duty to keep information about your health confidential. So, if they were to disclose your data in breach of that confidence, the use may be unlawful under this principle as well. In practice, when we think about lawful grounds of processing, there are several key things to keep in mind. First, as I've mentioned already, you must have a valid lawful ground in order to process personal data. There are 6 available lawful grounds for processing, and we will talk about these shortly. You must identify a lawful ground before you process personal data. You should document your lawful grounds for processing. You have to set out your lawful grounds in your privacy notice. And if you process special category data, criminal conviction data, or data about offences, this requires additional attention. There are 3 key building blocks for understanding the lawful ground of processing. Specifically, we are looking at Article 6 of the GDPR today, lawfulness of processing in relation to personal data. Then there are Articles 9 and 10 of the GDPR for special categories of data and criminal convictions. And lastly, local country law. So in the UK, the Data Protection Act 2018, which sets out further details in relation to certain types of processing. As I've already mentioned, Article 6 of the GDPR sets out the 6 grounds for lawful processing of personal data. You need to identify one of these grounds before you process personal data. Nuria will take us through the grounds of consent, legitimate interest, and performance of a contract, and I will then take you through legal obligation, vital interests, and public interests in more detail.
Thank you, Kate. So we will start with consent. You can rely on consent as lawful grounds for processing if the data subject has given his or her consent. We will look at what consent looks like under the GDPR. And we'll start by looking at the definition of consent and fleshing out its elements. Under the GDPR, consent must be a freely given, specific, informed, and unambiguous indication of wishes. For consent to be freely given, individuals will have to have a real choice and not feel compelled to consent. Consent should not be bundled with contractual terms. For example, signing up for a service should not be conditional on consenting for processing activities which are not necessary for the provision of that service. For instance, receiving marketing communications. If there is an imbalance of power between the individual and the controller, consent will not be the right justification for processing. The most obvious example is the relationship between an employer and an employee. For consent to be specific, it must be granular. This means that individuals must be given the possibility to consent for each specific purpose for processing. Individuals must have a specific choice for each purpose, and consent will have to be refreshed if the purposes for processing change. Finally, in this slide, consent must be informed. This means that prior to obtaining consent from them, individuals must be provided the relevant information about the processing activities so that they can make an informed decision and understand what they are agreeing to and what rights they have if they change their mind. Information must be clear and accessible to individuals and shouldn't be buried in a document which deals with other matters. The definition of consent under the GDPR also provides insights as to consent mechanisms, and these will require that the individual makes a statement or that the individual makes a clear and affirmative action. Unambiguous consent requires a clear affirmative act, for example, pressing a button. This is the lowest consent standard under the GDPR. Explicit consent, which is required, for example, for more sensitive processing activities, will require a statement, for example, a written statement and a signature, or that the individual ticks a box to say, I consent or I agree. European regulators have warned against avoiding clicking fatigue, where individuals just click, click, click and consent without considering the information provided. This is a challenge for controllers when designing their consent mechanisms. As technology develops, controllers come up with different ways to obtain consent from individuals. Before we move on to other legal grounds for processing, I will briefly go through other interesting points on consent. As part of complying with the accountability principle, controllers must obtain valid consent, and be able to demonstrate it. If consent is given in the context of a written declaration, which has to do with other matters, consent must be clearly distinguishable. The GDPR regulates the condition whereby controllers may obtain consent from minors when providing information society services to these minors. Minors who are years old or above will be able to consent themselves. When minors are under 16, the controller will have to obtain consent of the parents or guardians of the minors. EU member states may lower the age of 16, but no lower than 13. Controllers will have to have in place mechanisms to verify parental consent. Individuals have the right to withdraw their consent, and they must be informed about this before consenting. Individuals will have the right to request erasure of their data upon consent withdrawal. If processing is based on consent, individuals will have the right to data portability. I will now move on to discuss the legitimate interest lawful grounds for processing. Businesses may rely on their legitimate interest in order to process personal data, as long as they are satisfied that the processing is necessary for the fulfillment of their legitimate interests or the legitimate interest of a third party, except when such interests are overridden by the interest of fundamental rights and freedoms of the data subjects. Controllers will have to carry out a legitimate interest assessment under the accountability principle. Controllers should document this assessment in a standalone document. When relying on the legitimate interest, the privacy notice will have to include a description of what this legitimate interest is. As I said earlier, controllers will have to carry out a legitimate interest assessment. The legitimate interest assessment will require controllers to carry out a threefold legal test, which will include a purpose test, a necessity test, and a balancing test. Let's look at these three tests in a bit more detail. When carrying out the purpose test, the controller will have to consider whether there is a legitimate interest behind the processing. This may be a legitimate interest of the controller or a third party. This may be the legitimate interest of an individual or a company. What is a legitimate interest is interpreted broadly, and it's, as such, not defined in the GDPR. The controller must think about what they are trying to achieve and have a specific outcome in mind. The recitals of the GDPR provide some examples of what might be the controller's legitimate interest, and these include preventing fraud or carrying out direct marketing activities. Once you have defined what your legitimate interest is, you'll have to move on to the necessity test. You will need to consider whether the processing is proportionate and necessary to achieve certain objective, or if the same objective can be achieved in another, less privacy intrusive way. Finally, once you have considered this, you can move on to the balancing test. When carrying out your balancing test, you will need to consider whether your legitimate interest is overridden by the individual's interests, rights, and freedoms. When doing this, you will have to consider a number of questions. For example, you will need to consider the potential impact of your processing activities on the individual. You will also need to consider whether the individual is in a vulnerable or in a weak position. For example, are they patients, or are they your employees or children? These individuals might be less able to understand the consequences of the processing. You will also need to consider the individual's expectations. Whether they would reasonably expect you to carry out such processing activities. If you process personal data in ways that the individual does not expect, they will lose control over the processing, and they would not be in a position to exercise their rights. I will now move on to consider contractual necessity. You can rely on the performance of contract, lawful grounds for processing, if you have a direct contract with the individual, for instance, to deliver a service to them. For example, where an individual has bought goods from you, you have to deliver these goods to the individual. So you will need to process their address in order to carry out this delivery. There are similar scenarios where these will not apply. For example, when you have a direct contract with a corporate customer or a vendor, and you process the personal data of their employees. To process such data, you will not be able to rely on contractual necessity because you do not have a contract with the individual. This legal ground for processing also applies when the data subject asks you to do something before entering into a contract. Remember that you can only rely on this when the processing activities are necessary for the performance of the contract. European regulators interpret this narrowly, so any processing activities beyond this will require other legal grounds for processing. Now Kate will continue taking you through the legal grounds for processing.
Thank you, Nuria. The next ground for processing personal data is the reliance on a legal obligation. You can rely on the legal obligation basis if processing is necessary for compliance with a legal obligation to which the controller is subject. So, for example, if an employer needs to process personal data to comply with its legal obligation to disclose employee salary details to HMRC, the employer, who's subject to that legal obligation, can disclose that personal data to the HMRC, but only as necessary to comply with that legal obligation. Again, as with other grounds for lawful basis of processing, the processing must be necessary. So you can't use this basis if you have discretion as to whether or not to process the personal data, or if there's another reasonable way to comply with that legal obligation without using the personal data. In addition, Article 6.3 of the GDPR requires that the legal obligation must be laid down by union law or member state law to which the controller is subject, and this will vary from country to country. In the UK, for example, the Information Commissioner's Office has confirmed that you can rely on this basis if you need to process personal data to comply with a common law or a statutory obligation. The next ground is vital interests. If you are likely to be able to rely on vital interests as your lawful basis if you need to process the personal data to protect someone's life. So on a practical basis, there are very limited circumstances in which you will be able to rely on this lawful grounds. If you can reasonably protect the person's vital interest in another, less intrusive way, this basis will not apply. And lastly, for our 6 legal bases, is public interest. You can rely on this lawful basis if you need to process personal data for the performance of a task carried out in the public interest as set out in law, or in the exercise of official authority as set out in law. This basis is most relevant to public authorities, so for example a water authority, but it can apply to any organisation that exercises official authority or carries out tasks in the public interest. The UK Data Protection Act sets out a non-exhaustive list of what the public task basis will cover, for example, processing necessary for administration of justice, parliamentary functions, statutory functions, governmental functions. And again, like many of the other bases, the processing must be necessary. And now we move on to special categories of data. As we mentioned earlier in our presentation, special categories of data require additional measures. And just to recap from our earlier sessions, special category data is personal data revealing racial or ethnic origin, health data, political opinions, sex life, sexual orientation, religious beliefs, or trade union membership. To lawfully process this data, you must identify one of the lawful bases we've just gone through under Article 6 and a separate condition under Article 9 of the GDPR. There are 10 conditions for processing special category data in Article 9 of the GDPR, and 5 of these require you to meet additional conditions and safeguards set out in local law, specifically Schedule 1 of the UK Data Protection Act. In many cases, you will also need an appropriate policy document to set out and explain your procedures for securing compliance with data protection principles and retention and erasure policies. To process personal data about criminal convictions and offences or related security or offences, you must again have both a lawful basis under Article 6 and either legal authority or official authority for the processing under Article 10. The Data Protection Act 2018 deals with this type of data in a similar way to special category data and sets out specific conditions providing lawful authority for processing it.
Thank you very much, Kate. So, we talked at the start about the learning outcomes, and we said that by the end of this session, you should be better able to identify the key legislative building blocks for processing personal data lawfully, explain the available lawful grounds for processing and when they can apply, and identify that additional measures are required for some more sensitive types data. We have explained that on top of Article 6, lawful grounds, you may need to implement other conditions if you process certain types of more sensitive data. We have also explained that some of these conditions may be set out in the local data protection laws of European member states, which supplement the GDPR. We have gone through every single lawful ground for processing under Article 6, which are available to you. Don't forget, the fact that consent is at the top of the list does not mean that it's the preferred lawful ground for processing. To the contrary, sometimes consent will not be desirable, for example, when there is an imbalance of power between the controller and the individual, for example, in an employment context. Also, be aware that you must choose and document one of these legal grounds for processing before you start processing data. So, this brings us to the end of the third session of Module 1 of the Get Data Protection Fit program. Next time, we will be looking at what are the rights of the data subject and when they can be used. And here are our contact details should you wish to get in contact with us in relation to this. Thank you very much for listening.